Good afternoon and welcome back for the final panel of today. As a continuation of the discussions and the symposium that we have started already, panel 2 this afternoon will focus on broadening the fight against impunity. I would first like to give the floor to the moderator of this session, Ambassador Philippe Lalliot.
Oui, ça fonctionne. Bonjour à...
Well, that works. Thank you. Good afternoon to everybody. First of all, we shall screen a video, a very short video, before we begin the substantive discussions on this second symposium panel. For those of you who may not be aware of this, the idea behind the video is from Senegal and France, the two countries that are co-facilitators on cooperation with the ICC. And the general idea was to avail ourselves of the celebration of this 20th anniversary of the Rome Statute to reassert as broadly as possible the support of states parties in particular to the court. Before we view this video, I would like, first of all, to thank all those who accepted to take part in the symposium, all these high-level personalities from states parties and civil society, international organizations, Francophonie, as well as civil society. I'll now shut up and have you view the video. Thank you. A very brief video. Thank you.
With the ICC, I'm fighting against impunity for crimes under the Rome Statute.
Avec la Cour pénale internationale,
gemeinsam mit dem Internationalen Strafgerichtshof,
I'm fighting against
impunity.
Fight against impunity.
With the ICC,
I'm fighting against impunity.
Avec la Cour pénale internationale,
nous luttons contre l'impunité.
With the ICC,
I am fighting against
impunity.
Avec la Cour pénale internationale,
je lutte contre
l'impunité.
Avec la Cour pénale internationale,
with the ICC,
I'm fighting against impunity.
With the ICC, I am
fighting against impunity.
With the ICC,
je lutte contre l'impunité.
Avec la Cour pénale internationale,
I am fighting against impunity.
With the ICC,
je lutte contre l'impunité.
Mit dem Internationalen Strafgerichtshof.
Je lutte contre l'impunité.
Con la Corte Penal Internacional.
Je lutte contre l'impunité.
Impunity.
Con el Tribunal Penal Internacional.
I'm fighting against impunity.
With the ICC.
Je lutte contre l'impunité.
Avec la Cour pénale internationale.
Avec la Cour pénale internationale, nous luttons contre l'impunité.
Voilà, vous voyez que c'était très court.
A very short video. Thank you.
Et je crois qu'on ne pouvait pas rêver meilleur.
This, I believe, is the best way to launch the second panel, which I am honored to moderate this afternoon. Before I give the floor to the three speakers next to me on this podium, let me proceed with a few brief introductory remarks. I start by saying that the fight against impunity is at the very heart of the mission of the ICC, which is 20 years old. However, we need to remind ourselves that what was said by the President of Nigeria, the President of the ICC, and the prosecutor go to the very heart of this vision. Through its successes and failures, international criminal justice has evolved from Rome over the last 20 years, and it cannot evolve without state cooperation. This is one of the topics we'll be looking at this evening. From that angle, there's a very strong link between complementarity and cooperation, as well as universality. There is also a very strong connection between the responsibility of the court in the discharge of its mandate and the responsibility of the states in supporting the court. And this speaks to the efficiency, credibility, and legitimacy of the court, and through it, international criminal justice as a whole. Let me also say that the court has come under criticism, and we are all aware of those criticisms. All of them may not be justified, but we cannot just set them aside. I am not aware of any national or international institution that cannot improve itself through such criticisms. The court, and this needs to be emphasized, is a very young institution. It's barely in its adolescent years at 20. And if there are any problems with its youth, there doesn't seem to be a problem with its design. We can revisit that. We must, therefore, agree that we cannot challenge the very existence of the court, which is indispensable for the fight against impunity. The court is also indispensable for peace and international security. This afternoon, we have the privilege of a distinguished team of panelists whom I will introduce quickly. They come from various backgrounds, some academics, some from civil society, and some from the diplomatic world. They will attempt to diagnose certain aspects of our court 20 years after, and hopefully put forth some proposals for the future. We agreed that each panelist will have 5 to 7 minutes, and I see my neighbor smiling, 5 to 7 minutes of speaking time, and I will be here to be the timekeeper to ensure that we can have a Q&A session after your statements from all those who are willing or will be willing to raise any such questions, so that the ambassador of Chile can draw the conclusions on our day at around 5:45. To my left, we have Professor Gerhard Havner. I will not dare to go through his entire CV, a very impressive CV. Gerhard Havner is a professor at the University of Vienna, professor of law and international law. He is an associate professor to several other universities outside of his country, Stanford, Bratislava, and Paris, among others. I believe he's also a member, and he will say it himself, member of the International Human Rights Commission, the Permanent Arbitration Court, as well as an author of several works and writings, and I was very impressed by all his publications. He attended the preparatory works leading up to the Rome Statute, and he also attended the Rome Statute. Professor, I now give you the floor for 5 to 7 minutes.
Excellencies, ladies and gentlemen, first I have to say that what I want to say are my personal views and not necessarily that of my government. 20 years ago, just we adopted the Rome Statute around midnight. Today, this day, the activation of the jurisdiction concerning of the ICC concerning the crime of aggression becomes effective. And it is 500 years ago that it was argued that Erasmus von Rotterdam found that the international peace is a common good of humankind. And the question arises now, how far does this decision on the activation of the jurisdiction of the ICC on the crime of aggression contributes to these goals of protecting the common good of humankind? The text on the activation of the jurisdiction regarding the crimes of aggression, finally adopted in last December, restricts the ICC's jurisdiction. In the case of a state referral or proprium motu investigation, the ICC is entitled to prosecute a crime of aggression only if both the aggressor and the victim state are bound by the amendment, thus restricting the jurisdiction to a little more than 30 states. And it is my view that the ICC is bound by this decision. Otherwise, the ICC would run into great legal and political difficulties. But this restrictive decision stands in contrast to Article 12 of the ICC statute, where these two criteria are applied only alternatively. However, we must also take into account that this restriction does not apply to the Security Council, so that a great responsibility is placed on this organ. Undoubtedly, the solution reached in New York brings us far from universality and could even be seen as a step backwards if compared to Article 12. One might even regret that the ICC can exercise its jurisdiction regarding this crime only among little more than 30 states at the moment, in particular smaller or medium states. But it must also be acknowledged that this decision is not without its merits. It is the first time in history that such an individual responsibility can be prosecuted in a permanent manner. While in 1919, the Treaty of Versailles established individual criminal responsibility for the breach of international morality, and the Nuremberg Statute criminalized the breach of the peace for a certain situation, that the ICC goes beyond them, and it is not confined to a predefined situation and is therefore likely to produce a certain preventive effect. One must not lose sight also of the fact that currently the main objective of international law is not primarily the elaboration of primary norms, but of secondary rules, in particular those of the enforcement of international law. Applied to the field of the crime of aggression, there are hardly any instruments presented to enable prosecution with regard to individual responsibility, and only few post factum instruments have been established so far. So, for instance, the tribunals of Nuremberg, Tokyo, the Hybrids Court, ICTY, and so on, they are only post factum instruments. But international law is not only past-oriented. Rather, in the pursuance of the objective of predictability, it is also future-oriented. In that regard, the decision on the activation of the court's jurisdiction in particular serves the purpose of achieving this future-oriented practice. The second purpose of this activation is the creation of the possibility to ensure the justiciability of this crime and to remove any doubts in this regard, as well as to remove the unilateral political element of this crime. It will be for the court to prove that this crime is subject to a clear construction, so the states are provided with a clear guidance. In this way, and if the court is following this policy, the enforcement system of the ICC will be in a position to contribute to the relevance and effectiveness of the primary rules relating to the crime of aggression. The removal of any doubts concerning the construction of this crime could also create a certain incentive for other states to ratify the statute. Accordingly, the decision on the activation of the court's jurisdiction over the crime of aggression opens the door to the prosecution of an egregious international crime in the interest of the fight against impunity, and is a first, perhaps small, but important step in the direction of protecting the central common good of humankind, international peace. We can only hope that other steps will follow. And the more states accept the jurisdiction of the ICC regarding the crime of aggression, the more the resolution will lose its restrictive character and effect, and bring us closer to the universal protection of the common good of humankind as seen by Erasmus 500 years ago. Thank you very much.
That was perfect timing. Thank you, Professor. The crime of aggression has been the subject of great discussion until a recent conference towards the end of last year when it was adopted. Now, I hope that during our discussions this afternoon, during the Q&A session, we will revisit this issue and find out whether other states should be encouraged to ratify the statute. I see there might be different opinions on this matter, but I'm not going to speak to the substance of it. I am simply the ambassador of France, and this is not what I need to, and what I need to say is that France may have some observations to make, but we will address them at the right time. Thank you, Professor, once more. I have to my right again, Madam Kumar, Ann Kumar. Ann Kumar, is that your name? You're to my right. Yes, I think we don't need to introduce you because most people here in the hall would know you. You are a lawyer specializing in human rights. You are the executive director of Africa Legal Aid. And I am not going to read out the very impressive list of your publications, articles that you have either published yourself or supervised their publication in the area of international criminal justice. Let me simply say to all those present here tonight that in 2014 you were designated as one of the most influential persons on the African continent in 2014. I give you the floor right away.
Thank you, Mr. Chair. Excellencies, dear friends and colleagues, commemorations are occasions not necessarily to celebrate, but more importantly, an opportunity to look ahead and reflect on what can be improved and how. On the occasion of the 20th anniversary of the Rome Statute of the ICC, how can the fight against impunity be broadened? I will limit myself to 2 points. Let me start with the number of state parties. While the current number, 123, is as such not bad, it is plain that there is room for improvement. The world's most powerful and populous states have not joined, nor have various states where the rule of law is disrespected or under serious threat. In recent years, we have even witnessed a negative tendency of ICC member states wishing to withdraw from the statute. These are matters of concern. Yet, what to do about it? We have to be realistic and modest in our expectations of what can actually be achieved in the next 20 years. We can and we should continue to stress the significance of international criminal justice. We must promote the ICC as a particularly important tool for deterring commission of international crimes and delivering justice for victims. But let's get real. Some leaders are not so likely to have an open mind. We live in a heavily politicized world. Economic interests, power politics, nationalism, and populism rule the world. In today's internet and social media era, it seems easier to trigger the selfish day-to-day underbelly feelings of people than to persuade them of the structural need to challenge the powerful and to show solidarity with the less powerful. Distinguished participants, let me be clear. I am not giving up hope. I am not suggesting that nothing can be done. There are ways that we can broaden and strengthen the ICC. My point here would be to enhance the image of the court as a body that objectively stands for the apolitical rule of law. Whether we like it or not, the court too often is seen as a political actor. We may argue that such critique is not right or fair, but the perception does exist. The court may seek to objectively work on criminal justice, but its legitimacy ultimately depends on whether people believe so. The future success of the court depends on such subjective perceptions of its work. In my modest view, there is only one way to positively influence these subjective perceptions, and that is by objectively and coherently and consistently applying the legal standards enshrined in the Rome Statute. As significant as the rights and interests of victims are, criminal justice is also very much about the rights and interests of the accused. In other words, both convictions and acquittals may serve justice well. For all purposes of clarity, I am not expressing concrete views here about the outcome of the Bemba judgment. I am just neutrally observing that the debate between the majority and the minority of the judges in the Bemba appeal judgment must continue. I believe that continuing this debate will, in the long run, help us achieve consensus on how best to balance the rights of all involved. If the court is seen as giving too much weight to either the interests of the victims or rather to those of the accused, it will not be seen as a place where the objective rule of law is applied. It might not be an attractive body to join. Ladies and gentlemen, my second point is that, and as the title of this session so clearly reveals, it is not necessarily the ICC, but the fight against impunity that should be broadened. I do believe and fully support a strengthening of the ICC, be it in terms of increasing the number of states parties, intensifying its cooperation with member states, or the extension of its jurisdiction with the crime of aggression, or perhaps some other crimes. We need the ICC, but pursuing success of the ICC is not a goal in itself. The ultimate goal is criminal justice, and as we all know, the ICC does not have monopoly on criminal justice. In fact, the ICC is a default court that only has a role to play when local courts are unwilling or unable to do the job. While the statute only refers to the ICC's jurisdiction in relation to national courts exercising territorial or nationality jurisdiction, I would submit that the goal and spirit of the statute also demand respect for the exercise of complementarity by sub-regional and regional courts, as well as the exercise of universal jurisdiction by national courts. Proper legal standards must, of course, be adhered to, but the Rome Statute provides for a decentralized system that rests on the notion of justice being done at home or as close as possible to home. We need a strong ICC that can fill the gaps in criminal law systems, but it is not the only court able and willing to do so. Hence, the aim should not only be to enhance a national cooperation with the ICC's work, but the ICC is well advised to also offer its expertise and resources to other courts seeking that same objective of international criminal justice. Thank you.
Merci beaucoup.
Thank you very much. I believe that your statement has raised many substantive questions, and I hope that along with your questions, others will raise further questions this evening pertaining to aggression and to an expansion of the mandate of the court, matters pertaining to the interests of victims and accused persons, and matters of complementarity and what have you. All of these are extremely important questions for the court and for international criminal justice, broadly speaking. We also have today with us the last speaker for tonight. Ambassador Ugalde is a great diplomat, ambassador for Costa Rica in the Netherlands, vice president of the board, coordinator of the Hague Working Group last year. And I also found out that you have represented Costa Rica 6 times before the ICJ. You were a lecturer at the Academy of International Law, and I believe that you too will make very interesting and direct statements that speak to the challenges and the weaknesses and strengths of the court, and probably the brighter future for international criminal justice, I hope. Mr. Ugalde, Mr. Ambassador, you have the floor. Thank you, Ambassador.
Everyone, being the last speaker on the last panel of such an eventful day and having to address universality, cooperation, and the crime activation of the crime of aggression in between 5 to 7 minutes, that's quite a challenge. But we'll try to say a few words about it. Someone asked me some time ago, what happens if a great deal of countries decide to leave the court? I said, well, it will be a shame, it will be unfortunate, but I don't think really anything is going to happen. The court will stay on. It's an institution that we created, is here, and is going to stay here for good. There's no question about the relevance of the court. I think everybody understands that. And as a matter of fact, I do believe that it embodies now the ultimate goal on international criminal justice. I think it is to stay here. The question is, how do we empower it? How do we make it, the outreach of the court, truly global? And I think that's one of those challenges. And obviously, the question as to how we get it to be universal on the one hand, and the other one is how do we get the states to cooperate with it, is the other big challenge. There is another issue here which maybe should have been addressed. I think my fellow speaker already addressed it, which is the issue of I forgot the term now, but the question of the importance of building up national systems of justice that are effective, complementarity. Complementarity is absolutely critical. Why I'm bringing all this about is because after 20 years, what we have found is this. Countries, states, more than ever, and particularly those states who are thirsty to have very competent and strong legal systems, are asking for the court for assistance to build up those systems. We haven't actually, at the time when we discussed building up the court and when we brought about the issue of complementarity, we never thought about the fact that the role of the court was to actually go to countries and help build up legal systems. But it seems to me now that we have to consider that, whether obviously this is not a judicial function of the court per se, but I think it is a responsibility for the Assembly of States Parties in cooperation with the court in order to build know-how and in order to provide guidance so countries can have the ability to do that. The following issue, of course, is how do we achieve universality? And the issue of universality is we have to keep banging on those countries that still don't believe on the court or who are afraid of the court or for whatever reason, we have to keep convincing them and convincing them with the right reasons. It's not finger pointing. It's about to tell them that it is good for their populations, that it is good for their own name, and that it is good for humanity to become part of this family. I think that's the right message, and we have to keep going on and on and on. And it is the responsibility of all of us. It is the responsibility of the court, it is the responsibility of the Assembly of States Parties, and it is the responsibility responsibility of each of the states member of the ICC to do so. There are ways in which we can do this. I'm not going to tell them all, but I think there are strategies in which we can implement that. And the third issue, of course, is cooperation. Without effective cooperation, we get nowhere. Without the assistance from the states, be this signing agreements with the court, being able to execute arrest warrants, being able to address questions of assets, as we had last year the opportunity to address this issue in Paris in a very exciting seminar on that issue. You name it, it is absolutely critical. But cooperation also means that we have to give the necessary resources to the court. It is what it is, you know, and frankly, I think that even though we are going through very challenging times, it is absolutely essential that we do not forget that. I know that we have issues in our own national systems, but in order to ensure the principles and the aims that we have set ourselves to accomplish with the court, it is necessary to give it the right resources. Lastly, with an institution like this, there's also comes responsibilities. And the responsibilities are from everyone, from the leadership of the court, from the leadership of the Assembly of States Parties, and from the leadership of each of us. We have a fiduciary responsibility toward this institution, and we need to make sure that we lead by example. And I think that is an absolutely critical issue going forward. Thank you, Mr. Ambassador.
Merci à vous.
Thank you very much. Once again, I believe there is a great deal of material to deal with in your remarks. I think it's now time to open up the discussion to anyone who would like to put a question to our panelists. You may ask a question individually or to all three panelists if you wish, having to do with anything related to the fight to end impunity. Sir, if you please go ahead.
Thank you very much, Excellency. I listened very, very carefully to the comments made by the panelists, and they're extremely important. But I will talk about one subject, in particular about the question of complementarity and also cooperation with states. For my 20 years, in different international criminal courts, the ICTR, Special Court for Sierra Leone, the ICC, and other courts, I had a lot of extensive contacts with regard to different states and state actors, and sometimes non-state actors who were involved in armed conflict in the exercise of the mandate that was given to me. And I want to say one thing with regard to this court. I think there should be some form of institutional dialogue so that we can learn from other courts, especially where they were strongest. For example, I was in the Special Court for Sierra Leone, and I can tell you the outreach program was very successful. My opinion, and with due respect, I recognized earlier this morning that there are reforms, visible reforms we have seen in this court, but we have to strengthen our outreach program. We cannot outsource it. Without an effective outreach program, not every department doing its own outreach, one person making statements on behalf of the courts, but we have to have a very effective outreach program so we can reach states, state and non-state actors and tell them about the ICC. The ICC, ICC might have achieved a lot in terms of jurisprudence and other areas, but it is not known. The next issue I want to say very clearly is that we know that international relations depend on the consent of states. And states are extremely, very, very jealous of their sovereignty. And states are predictable because of the changing world dynamics. And also because of the practical alliances. States which may be encouraging the ICC, under different circumstances, as the director of Legal Aid Africa said, those states might be the ones asking the ICC not to cooperate, depending on the change dynamics, their commercial and geopolitical interests. And therefore, what do we do? For the ICC to succeed, the Rome Statute must be domesticated. One of the key actors of key factor of ascertaining whether the court has the capacity to investigate and prosecute first should be, have they domesticated the Rome Statute? And even non-state parties, if they domesticate the Rome Statute, it is a victory for the ICC that we are fulfilling our mandate. 2, international cooperation. The court has a judicial function, but the court also has a diplomatic function. Our international cooperation should be able to talk, to know that state would like to be convinced. You don't address state on the media. You address state by effectively talking to them and explaining to them that it's in their interest if you let us in to investigate and let them know, exchange of communication. I think there are so many issues that will be avoided, conflicts that will be avoided if we set appropriate structures within the court first, and at the same time, we set appropriate standards. Thanks very much.
Merci à vous. Ça n'était...
Thank you. That wasn't entirely a question. It was more of a very interesting series of observations. Would any of our panelists like to respond? Or any one of you? All of you? Would you like to remark?
No, sure, I know. Et je sais sur quel sujet, pardon.
Yes, I think I know which topic.
I got the impression that you said that this argument that the clarification of this jurisdiction could lead to an increase of the membership in the Rome Statute is a little doubtful. But on the other hand, what could happen that presently we have now a clarity concerning the interpretation of the jurisdiction concerning aggression. And this certainly removes perhaps certain doubts with the states concerning this interpretation. And by this, they have a certain guidance on the interpretation of this. And it could be that this contributes to the fact that they are rather more inclined towards ratifying the statute without even the aggression. Because this is, with the opt-out declaration, it's very easy to achieve.
Je vais essayer de rester aussi neutre que...
I will endeavor to remain as neutral as possible, given that I'm the moderator. Now, just very quickly, in response to one point that was made, in the current circumstances, the court has come under certain criticism, and I would tend to think that it might be better to stabilize the court and its field of jurisdiction before considering an expansion of its jurisdiction. That would be my first remark. So it's not so much an observation about the principle, but rather the timing. I do wish to raise a question of principle that has to do with aggression and the definition of this crime. Could there be a confusion between a crime of aggression, something that could come to the court, and then a crime referred to the court by the Security Council? So you see, we have these two arguments, as well as others, and I believe that these are not necessarily helpful in clarifying the situation. Perhaps these two possibilities make things more complex and more muddled, indeed, rather than clearer. I can see Mr. Keita, who would like to take the floor. If Mr. Keita would like to speak to that remark, or another. Mr. Keita, if you could kindly stand up, and as an experienced and brilliant advocate, of course, you will do so. Please quickly introduce yourself and then put your question. Thank you very much, Mr. Ambassador, and I do thank you and all the panelists. I'm Jean-Xavier Keita, and I have been a lawyer for nearly 35 years now. I am the current Principal Counsel at the Office of Public Counsel for Defense here at the ICC. First of all, regarding complementarity, I would like to say that there is no point if the states parties or the international community do not try to truly form the local stakeholders in the field. We talked about positive complementarity in the early days of the court. We no longer talk about that. So I thought that was one of the most creative things that came out of the Rome Statute, one of the finest things, that concept of positive complementarity that would allow us to establish something at the local level so that the court would not be hindered by matters that otherwise that could be dealt with at the local level. There are some issues we have not fully considered, and I think that really has to, well, this has to come from the court. There has to be a mea culpa from the court. The court has to be much more aggressive in its communications. I am, in any event, when I talk about the court, and when people say to me that it's a colonial court or that it's a court that only is there for Africa, I can marshal legal arguments to show that that is false. And what's more, that the current cases and situations before the court stemmed from initiatives from the African states themselves. And in actual fact, they were disturbed only when the court began to look into the dealings of certain sitting heads of state, and that was very much to the merit of the court. I would also like to say something else. I think we need to think about universality. I will switch in English.
I think we should think to the universality about how young professionals have a unique opportunity to join the court, meaning intern, visiting professional, and they receive back no money to help them. And living in The Hague is very expensive. I think that by stopping to give an opportunity to young professionals to join the court for a while, that create a selection. Only those who have the means have an opportunity to join the court. And this is a bad way to go through or to try to reach universality. I think through the young professional, we can open the court because those young interns will become the future young professional joining the court himself or convincing the states to join the court. We should explore this. Thank you.
Merci. Trois sujets.
Thank you. 3 points that I'll raise for our panelists. Complementarity and sovereignty. It is true that that is one major point, this linkage or relationship between the two. Then secondly, I think this has to be said straight out, that the ICC is called a colonial court, sometimes administering victor's justice. And I constantly am saying that the court is interested in a number of situations in Africa. It is because the victims are African. That was your second point, Mr. Keita. Then finally, if we look to the future, we should convince the future generations to turn towards the court and look to the court. Would any of you like to respond to these 3 points, these existentialist points raised by Mr. Keita?
Thank you, Mr. Chair. On questions of complementarity, as I mentioned before, it is one of the cornerstones of an effective international criminal system. Obviously, this is a court of last resort, and that's still it is that. We didn't set it up in order to put our noses into internal country's affairs, unless, of course, there were elements, objective elements, which indicate that there is an actual case to be made. in which the court may activate its jurisdiction. What I was referring earlier, of course, is the fact that in question of cooperation, which I missed to say, that this is a two-way street. I mean, there is a cooperation that is necessary and is absolutely fundamental from countries to the court, but I also think that there is more that we can do as an institution, and I'm not talking particularly about the judiciary, but as to the institutionality of the ICC and the Rome Statute in order to be able to support and strengthen national systems without obviously interfering with national politics. I don't think that's what is aimed here. Concerning issues of universality, well, of course, it is obvious that we need to make more in order to really make this a global institution, be this by way of not only inviting young professionals, but actually making sure that the court itself is aware of the importance to have a great deal of regional, a regional balance, a true regional balance, but also fairness in female and male postings. I think those are issues that still we are lagging behind, but I think that we are going in the right direction in that sense. Lastly, I would like to say something concerning the activation of the crime of aggression. After all, this court, I mean, if you see the history of this court and all of the efforts that were carried out as of after post the Nuremberg tribunals and the Tokyo tribunals, it was because of the crime of aggression. That was the whole idea. I mean, the idea of an international criminal justice is based on that. The fact that in 1998 we didn't manage to come to an agreement as to how far we were going to go there, it doesn't mean that we owe to a great degree the fact that we have what we have on those bases. And not just because of the crime of aggression on itself, it's because of what is represented. So I will have to disagree a little bit in the sense that we are getting ahead of our times. I think actually we are right on time on this one, and maybe a little bit behind, but it's done. Today, the crime of aggression is activated, and I think at the end of the day, whatever decision needs to be taken, I mean, there are two decisions twofold. There is the strictly legal decision as to when and in which conditions the court may have jurisdiction, which is a decision for those ladies and gentlemen there, and not for us to make a decision. And there will be the political decision, of course. And we understand that because that's the realm in which we are in. But I think we should celebrate the fact that we managed to do this, that we finally being able to make good by activating aggression as it is, and we have to let now the court make its job when the circumstances reach that situation. Thank you.
Thank you. I would like to think of the ICC as a default court. I know that the term a court of last resort is often used and accepted. But last resort would seem to suggest that you go through the various stages and then the ICC is like a court of appeal at the international level. I'm sure that's not what people mean when they say it's a court of last resort, but I prefer the term default court. So complementarity it is. I'm glad that I'm glad to hear the various sentiments expressed by Chief Taku and by Xavier Jean about the need to support complementarity at national levels. I would add also at that we should consider sub-regional courts exercising complementarity and regional courts also exercising complementarity. I like the suggestion about young professionals. The youth is a very huge population in Africa. These are the future leaders of Africa. So if we engage them at this, early on, that would be really good. And, I agree, because in my organization, we get a lot of requests from interns, from people coming from the US and other places who have their own funds. And if we would only only allow people who have their funds to come, then many Africans would not be able to have this experience. So we really do go out of our way to engage African interns.
Thank you very much. When you have a look in all the dictionaries of English language, as far as I know, you don't find the word complementarity. It is a neologism. And so this characterizes the innovative aspect of the complementarity in the ICC. I still remember when we negotiated this, there was also the idea to replace it by subsidiarity. But then we left it with a complementarity, despite the fact that it was a neologism. This was quite interesting. And this is certainly a cornerstone, and this is certainly also an instrument, a tool, to protect, as some say, the sovereignty of the states. And so the states have two possibilities, either to cooperate with the court or to prosecute on their own. And this certainly has an effect on the battle, the fight against impunity. As to this, your proposal concerning young people, young lawyers, of course, I fully subscribe it. But, as it was just said, you have to be sure that the right are coming. And when we negotiated the ICC, I still remember when there was the discussion how far personnel, not from state coming, could be included in the ICC. And there was the fear that the ICC could come under a certain influence. And this should be halted for this reason and should be abolished or avoided. And for this reason, you have a certain compromise formula in the Rome Statute itself. But in any case, I find it is an excellent idea if you have the right people. And another possibility, and that has been used already, that are the moot courts. The criminal tribunal moot courts. And there you could get the students from the universities of the states that are not yet parties to the statute. As to the aggression, what I wanted only to say is, what we have, we are confronted presently with a criticism of the decision in December. And in my view, what should be taken into account is that it has also a positive aspect. And this should not be lost sight of. And so I think we are in the same direction going. Thank you very much.
Merci.
Thank you. Other questions, points? Yes, Mr. President? We're very pleased to have you with us this afternoon.
Very much. Right, I will not get involved in the discussion on whether or not it's the right thing to have the crime of aggression, but Ambassador did point out that in Nuremberg, there was that jurisdiction. In fact, he is correct. In Article 6A of the Nuremberg Charter, it does have the crime of aggression was one of the crimes over which those who adopted the statute gave that thing jurisdiction. Now, but my question to you, Ambassador, is on the matter of complementarity and assisting in the development of capacity for purposes of helping with complementarity, making it real. It is a suggestion we've had a lot, and it has a lot of merit in my view. The question, of course, for you, as a representative of a state party and an important member in the Bureau and all that, is what does that do to the concept of zero budget? Because it's all well and good to want these good things to be done, but if we don't have the money to do it, how would that work? Or are you supporting to increase the budget to make that work? Thank you.
Merci beaucoup.
Thank you very much. I think that complementarity allows one to make savings. I'll allow the ambassadors to respond.
Chair, thank you, President. Look, I think there are ways in which we can support complementarity. Cooperation, as I was saying, is a two-way road, and I think there are ways in which we can see, for example, best practices. I think that the court already have accumulated a great deal of practice and experience that can be shared with states that are thirsty for that. I also think that there are ways in which we can ask some partner states willing to finance specific programs for complementarity to do so, and I know that there are countries that will be willing to do so. I won't say which because I'm not going to compromise countries, but I think there are ways in which we can do that. We can do this also. We already been doing this by way of seminars. Many of the seminars that the court has hosted in the last years goes very much towards that. But indeed, I agree with you that there is an aspect, there's a financial aspect that needs to be addressed directly from the point of view of the court. And as I stated earlier, I think that it is only fair that we give the resources that the court needs in order to be able to fulfill its mandate. Obviously, its primary mandate is obviously the judicial activity, and we must not lose sight of that. But at the same time, I think there are creative ways in which we can address the other aspects of the court activities, engaging with the communities, engaging with other countries and regions in a way that will not affect so seriously the budget. But said that, I also think that there are still ways, and I think we have a very vigorous discussion between the states parties and the court as to how to make it effective and how to obviously try to make sure that any increases on budget are according to the means of the countries. And of course, there is that ongoing discussion. But I am sure that as the spirit of cooperation that we underlined earlier marks the relationship, we can always be able to get agreement on that and move positively. And I think I want to draw on the positive aspect of conversations and dialogue between the court and all the other stakeholders.
Merci.
Thank you very much, Ambassador. Indeed, on that particular topic, sometimes we do have that conversation. In complementarity and, well, we're looking at two sides of the same coin, really. There's the contributions to the court, there is complementarity, and there are other forms of contributions that can be made. That would be my first remark. Secondly, as a representative of a state party, I must say that we are very much convinced that the court should receive the resources it needs to carry out its work. But I do need to remind you that the court is funded by national funding, and in many countries funding is in short supply and public spending is quite restrained. So you have to strike the right balance between the funding requirements of the court on the one hand, and then, well, in an ideal world, of course, we could allocate endless resources to the court, but this is not necessarily a world we live in, and each and every year we need to strike that balance. Sir, you have a question? Judge Antoine Mindoif of the ICC. Thank you very much, Mr. Ambassador, for your remarks. First of all, I'd like to thank the panelists for their contributions this afternoon. I agree with them in that the court is here and the court must remain. One can question some aspects of its operations, but one cannot question its existence. Now, criticism has been leveled against the court, and if the criticism is unfounded, that's one thing, but on the other hand, at times the criticism is merited. Some states parties, some African parties are discouraged, and they talk about leaving the court. Yet we need a truly universal court. One of the criticisms is that there's a double standard at play, that some states, particularly African states, are targeted while other states are not at all. To my mind, this situation is due to a congenital malady that one finds within the Rome Statute itself, namely schizophrenia. The ICC is based, on actual fact, on the principle of the relativity of treaties, and that is found within the Vienna Convention. The effects of a treaty are exercised only upon parties and not upon third parties. Thus, in principle, the ICC should only deal with matters relating to states' parties. Yet at the same time, the Rome Statute authorizes the UN Security Council to intervene and deal with the actual work of the court. Certain Security Council members that are not that have not ratified this statute were part of the process referring matters to the court or not, thus blocking the work of the court. At the same time, we are fully aware that the United Nations at times refuse to pay for situations that they themselves have sent to the court. Thus, I would like to call upon states parties to begin a frank and open dialogue about the dealings between the ICC and the UN Security Council. In my opinion, the work of the Security Council is very important to the work of the court. I do have a few personal ideas in this regard, regarding the dealings between the court and the Security Council. I won't venture down that particular path, but in any event, I throw out the question and I'll leave it at that. Thank you very much. There was a very interesting meeting about 15 days ago in New York that dealt specifically with the dealings between the ICC and the UN Security Council, indeed. And the meeting was organized by it was at a Senegal and France that dealt with the matter using an ARIA resolution, and it was quite a practical session without going into psychoanalysis, psychiatry, or other fields of endeavor. We did look at these issues because, yes, one institution cannot function without the other. Would anyone like to jump in and say something? Anything about schizophrenia, for example?
Thank you very much. There are two questions. The one is the financing of the ICC, and the other is the relation to the Security Council. In the negotiations of the Rome Statute, we had quite a lot of time devoted to the question of the relation to the Security Council. And so we have now the effect. But if you make the argument of Article of the Vienna Convention on the Law of Treaties concerning the third party effect, Pacta Tertius rule, then the Security Council power does not stem from the Rome Statute itself, but rather from the UN Charter. And there you have Article 103. Saying that the obligations under the Charter overrides any other conventional obligation. So we have to see in this perspective. Of course, it is quite clear that it is a problem that the ICC statute empowers the Security Council to refer certain situations to it. But on the other hand, you have also to see that if it is done by the Security Council has universal jurisdiction according to the Charter. This is the problem. And I think it would have been very difficult to restrict the power of the Security Council in the Rome Statute, unless you say you cut it off. This would have been a possibility. As to the budget, I personally was involved in the negotiations on the budget. The first idea was that the UN should, that the budget, that the ICC should be financed in the first time by the UN budget. Because if you have only few states, then it is more difficult for these states really to finance the first phase of the ICC where you need more money. And this was rejected. So we have then this particular compromise in the statute itself. And you have in the statute also the provision that if there is a referral by the Security Council, then it should be regarded that it is financed by the General Assembly. And in very careful terms it is there. But in two cases, I think it was so that the resolutions of the Security Council explicitly states that financing by the United Nations does not occur. And I can imagine why this has happened. And I think you know also why this happened. There's no need to say something about it. Thank you.
Merci.
Thank you. I'm pleased to see that people are raising issues having to do with the dealings between the ICC and UN bodies. I think that this is something that perhaps could be applicable to the other discussion we had about the crime of aggression. Ambassador, would you like to add something?
Very briefly, I think this issue about the financing of cases referred by the Security Council to the ICC is a matter that is urgent and needs addressing. And I agree with the judge that you cannot wait this any longer. It is important. Now, I don't see in the going forward, I don't see the UN setting up new ad hoc tribunals for dealing with international criminal matters. I think that they know this is expensive. We already have a permanent court, and it would be dollar by dollar far much cheaper if you are going extremely only on the economic terms to do it here than do it anywhere else. And I think that is an argument that we have to make, and I think there is a way in which we can come to an arrangement. It was going to take time, but I am sure that the leadership can take us there. But I believe also that it is also the right way to ensure that this will be the central institution for dealing on issues of international criminal justice. So we have consistency and legal security as well. So I believe that we will get there, but it will take a bit of diplomatic work. Thank you.
Please.
Merci, Monsieur le Président.
Thank you very much, Mr. Subaruti. And I'm a researcher within the African Legal Documentation Association and a member of the coalition. I'd prefer to speak in French, if you don't mind. We're short of time. And I'd like to congratulate the panelists and ask our panelists of this idea of associating other courts with the work of this court. I agree that, yes, complementarity between the court and others, but I don't agree with the idea of having regional organizations involved in the prosecution of criminals at the sub-regional or regional levels. In some cases, countries are unable to arrest or investigate such people, and I think this would be a very bad thing, because what would happen is people would say, oh, you must turn to the regional or the sub-regional body before you can turn to the court. years would go by. And I do hope that this issue will not be exploited, because I think it could actually take us 20 years back. Thank you very much. I believe the question was very much for you, ma'am, so if you'd like to go ahead.
Well, it's complementarity. Justice done at home or as close as possible to home. You know, it's just better. I understand the issue of funding, and I know that with the Malabo Protocol there are some issues with the immunity provision. But you know, if you know, in an ideal world, yes. I mean, first of all, it should be at the national and territorial state. If that's not possible, why not the ECOWAS court? Why not give them the mandate? Why not the East African court? Why not the sub-regional courts? I mean, the more, the merrier. It's all complementary to the jurisdiction of the ICC, I would say.
Merci.
Thank you.
Je vous en prie, monsieur, allez-y. On va vous passer.
Yes, over there, you, sir. Please wait for the microphone.
Thank you. Mohamed Bangura for the Residual Court for Sierra Leone. I'm just following up on the question which was posed a short while ago to Ms. Ankoma. And this is from a different angle. I think it's a good idea that we should help to close the impunity gap with the efforts of regional and sub-regional courts. But how effective is complementarity, where some of these regional and sub-regional courts do not meet certain standards? For instance, the African Court currently has a provision or statute that does not recognize the principle of head of state immunity, which is a very fundamental principle in international criminal law. The Special Court for Sierra Leone tried and convicted Charles Taylor, who was a sitting head of state at the time that he committed those crimes. So what happens, how effective is complementarity in this circumstance where a regional court is not able to deliver? Does the ICC then not have the authority to step in? I mean, then how effective is complementarity? Thank you.
Merci beaucoup.
Thank you very much.
Complementarity is not just about the Malabo Protocol and the immunity provision in the Malabo Protocol. That is an unfortunate provision. I do not subscribe to that. That's an unfortunate provision. Advocating for sub-regional courts to have complementarity does not mean that they should also have the immunity provision in the Malabo Protocol. In fact, the Malabo Protocol has quite some very good provisions. It expands, I'm an expansionist, it expands the list of offenses that, that constitute international crimes. In fact, it was inspired by the Cairo-Arusha Principles on Universal Jurisdiction adopted under the auspices of Africa Legal Aid. So it's got some very good provisions. It's just that one immunity provision that is a problem. But should that be a reason to stop the Malabo Protocol from going forward? Not necessarily, because there are others who also commit those crimes who may not necessarily be heads of states. And you know, another argument is that how realistic is it? I know I have to be careful to prosecute a sitting head of state. Wouldn't it be better to, you know, try to get them out of office so that you pursue them? So complementarity, it's the cornerstone of the ICC statute. We must promote it. It does not mean that we subscribe to the immunity provision in the Malabo Protocol.
Merci beaucoup.
Thank you very much. I see many fingers, but we don't have much time. I'll give the floor to you first, sir, and then I'll move over to the ambassador of Chile. Eugene Bakama, Club of Friends of the Court in Congo. I want to hear what Professor Gerald's point of view is in relation to aggression and the Malabo Protocol. You see, the definition also takes into account non-state stakeholders. What is your view on that, sir?
Aggression is a problem. And if you have different definitions, one is for the ICC and the other is for the regional court. And that the two courts have to apply their own definition. So it doesn't happen, there is no greater problem if there are two different definitions. It is quite clear that the definition accepted for the ICC is not decisive for the other courts. They are free to decide their own, to take down their own definition.
Merci, Madame l'Ambassadeur.
Thank you. Madam Ambassador, I'll give you the floor for the last question or the last remarks or closing remarks.
Thank you.
Sorry, thank you very much. The question is a mixture of academic interest and also diplomatic interest. It is the place you foresee for those initiatives to enhance the mutual legal assistance in terms of investigation and prosecution of international crimes. There are some studies at the International Law Commission going on, and there is also a diplomatic initiative that is gathering a number of states, and the interaction with the Rome Statute. That this is a practical concern. I'm not opposing the initiative, but just the question of how do you see the interaction. Thank you.
Merci. Qui est-ce qui veut?
Thank you. Who would like to answer from among three of you?
Ugalde?
I think, Ambassador, that this is a system still very much in construction. I mean, just as a general international law, any aspect of the general international law, there is not a particular aspect of international law that we can say that is fully ready in the sense that is constantly, first of all, it is evolving, and second of all, there are still aspects of international law under construction. So I think it will take still some time for us to be able to have an integrated way in which different aspects of the discussions and different working groups are addressing issues that on the face of it may even seem the same. When you go into the minutiae of the aspects being under discussion, you understand that there are different aspects that are relevant, but that still require action. And action in the multilateral system is difficult, as we all know. So I think it's a question of time. I think little by little we will get there, but I would not say that there is an issue concerning not being effective moving forward. I think that eventually we'll get there.
Professeur, un dernier mot?
Professor, a last word. Would you like to take the mic again?
I misunderstood you. Did you address the project of the International Law Commission? In the International Law Commission, they just finished the second reading of the draft articles on the crimes against humanity. And this raises the question of the relation to the ICC. But I think that would be too long to answer this.
C'est une manière un peu abrupte de...
Well, we somewhat come abruptly to the end of our discussions, but it is also the beginning of further conversations. We must stop here now, and I want to thank the three panelists. You have seen the various questions raised and the many that remain unanswered, which testify to the interest that has arisen from your statements. And I will not attempt to draw any conclusions pertaining to our discussions of this evening. I now believe that the floor is to the ambassador of Chile, who will take us to the end of this day. Do I give you the floor directly, or what do I do?
And I'm sure he will know exactly what we have to do now. Merci. Merci encore à tous les trois.
Thank you. I thank the three panelists.
Buenas tardes. Voilà. And I will introduce the remarks in Spanish and finish in Spanish, and then to use English in the middle. El tema de nuestra jornada.
The issue that we have dealt with has been given the title, The Enduring Value of the Rome Statute to Humanity. Now, in these final words, I will refer to the different ideas that have been common to all the presentations, as well as to certain proposals that we can see that that have been put forth. The court is here. The different bodies of the court, the states parties, and there are representatives from academia, from civil society, from the press, a number of experts. The exchange of opinions has been outspoken and open, and I will try to be equally frank in my conclusions.
That result from today's discussions. By general debate and two panels, judicial technical issues as well as political and systemic issues have been discussed at length. We express our deepest appreciation to all the participants who have contributed to present a more comprehensive and fair picture of the Rome Statute today. The adoption of the Rome Statute in 1998 represented, as the introduction made by the Ambassador of Denmark made some days ago, a gift of hope to future generations. Those were the words of former United Nations Secretary General Kofi Annan. Today, that promise endures. At the same time, there is widespread concern that this gift of hope is not complete but deserves renovated views on what international criminal justice means amid an ongoing discussion about the universal value of a criminal court. In this session, high-level representatives have highlighted on the lasting significance of the International Criminal Court, and reflections have shown an increasing trend supportive of its current competencies and characteristics. But there has also been the question about whether the international community must revitalize its efforts to renew the ideas that expanded through the 90s to ensure the accountability for the gravest crimes. On the part of states, the responsibility to think of an improved court and a more efficient procedure is still present. The ICC's decisions originate from a courtroom, but their impact on the affirmation and development of international criminal law go beyond the individual cases. Cases involve opinions and decisions. Although we must observe judicial independence, states and the international community cannot refrain from analyzing the issues involved and the way they may impact ongoing situations or deter future conduct. At the same time, a court does not replace the role of international political organs and of states' policies, but when it has been granted the power to carry out functions of investigation and prosecution in full respect of the legal requirements, the court deserves not only symbolic support, but also tangible tools to pursue its duties. Among the dimensions that the practice renders visible is that the Rome Statute system operates not only through the court itself, but also by means of the Trust Fund for Victims, both of which are intertwined with the will and aspiration of a highly heterogeneous international community. This unique feature that was widely addressed today is of utmost importance to understand the system created 20 years ago. This may be called the valid expectation of the community affected by grave crimes. We know that to deliver justice for victims and communities affected by the status crimes, the court operates in a complex and evolving political environment. It is thus more important than ever to strengthen the idea of the possibility to foster common values against impunity of core crimes and accountability to justice. Another dimension that has been highlighted today is that the Rome Statute connects justice with the domestic systems. As it has been said, the criminal justice system set out by the statute reverberates at the national level through the principle of complementarity and its active effect in mobilizing domestic legal instruments. All panelists have taken a look at the accomplishments and results of the ICC's judicial process and assessed ways in which it may be enhanced. At moments, this view may seem more critical because of the length of the proceedings and the difficult adjustment of different legal systems stemming from common law and civil law characteristics. Critical voices may also arise out of regional or national circumstances, aiming to take distance with international institutions. Institutions must take note of this phenomena and seek to enhance their own capabilities to persuade and produce changes in the direction that may bring more credibility and respect for their decisions. Regarding announcements of withdrawals from or of non-cooperation with the ICC system, while the precedents cannot be denied, the way we engage with the relevant parties may make a difference in the real world. Looking forward, all participants, including high-level authorities, have expressed hope that this symposium would have helped to better understand the world in which the Rome Statute operates and the needs that are yet to be satisfied. It was striking to listen to one voice that aligned the objectives of the statute with the preservation of peace. The reparative value of the court system was also highlighted. The Rome Statute has entered a new decade and it must continue to expand in terms of participation. In order to ensure accountability for the most serious international crimes, we need to consider the national and international strategies of states based on the values of the international community. Some of these values are under constant strain. The entry into force of the jurisdiction of the court over the crime of aggression as of today adds urgency to the search of responses to these questions. Allow me to highlight some salient ideas and reflections that arise out of today's discussion. If on the technical side, making the judicial process more efficient and accessible to victims, as well as considering the defense rights and related financial needs, the political and systemic elements also deserve a fair attention as they are essential to state parties. Cooperation and universality are central in this regard. On the other hand, behind concepts such as efficiency and integrity of the functioning of this court, there is a third dimension that consists of oversight and accountability. These dimensions imply duties not only for the court, but also for state parties, which are subject to the discipline of participating in a highly demanding international judicial system, dealing with crimes whose connotations are to be rejected by all states. The opening statement highlighted that there have been achievements over the 20 past years and that there remain challenges for the years ahead. The next question is, are there existing situations that should attract our attention and towards which the current tools are not applicable or useful? What are our ambitions in this respect? A wide range of subjects and evolving circumstances are permanently interplaying and affect the way in which we states perceive the system and the associated demands. The focus has been placed on the efficiency of the judicial process, participation of victims and assistance to affected communities, cooperation, universality, and about the entry into force of the crime of aggression. The way to discharge requests of the Security Council remains one of the central questions when we assess the ICC response to the Council referrals, and we recall the appeal made by one of the speakers of the need for a constructive approach still to be built. Ancillary to the efficiency of states' participation and awareness about core situations are non-governmental organizations which bring an attentive view on matters and remind us not to forget our core duties and to shape policies aiming to enhance the efficiency of our own participation in the Assembly and subsidiary bodies. I need not remind you about the crucial role that non-governmental entities have played to foster the concept of complementarity in the broad cooperation framework. Thoughts on ratifications, accessions, and other actions related to the law of treaties have also been shared among us. This is a good moment to underscore that the universally inclusive character of the statute is essential for its power and effectiveness. It should never be a court for a selected number of states, but rather a court for the international community united around core objectives. Again, this requires a constructive approach. On the other hand, the support of states must translate into legal and material means to perform the duties that are embedded in the statute. Building on arrest strategies of suspects is one of the tools to enhance the effective power of the court. This means a new engagement with those that do not feel at ease with this special form of accountability and that cannot build an internal consensus to support the participation in the ICC system. It also means reaching out with a positive narrative about the achievements of the international criminal justice rendered by the ICC, as opposed to the limited vision that turns around numbers of cases and indicted persons. The value of regional approaches was also mentioned in order to overcome the distant gap with the local societies and that underrepresented regions. For the future, there remains various issues to address, and state parties, the court itself, and the civil society will have to continue strengthening their mutual understanding of threats and opportunities. We may need to narrow the material and geographical distance between the alleged commission of crimes and judicial responses, including the possibility of operating in the proximity of the area in which the crimes allegedly occurred. To continue thinking on how to rebuild trust and links with the Security Council and its permanent members, which are not yet parties to the statute, this is another challenge for the future, for the present and the future. It is time that members of the Security Council adopt policies and decisions to render more efficient its relationship with the ICC while respecting its independence and supporting its financial needs. Mention has also been made on the need to use more intensively the governance mechanisms of the Assembly of State Parties to assist the ICC to increase the efficiency of the judicial process. This is apparent, for example, in the process of studying amendments of international norms and the rules of procedure and evidence, as well as the speed and efficiency at which we states address these matters. On cooperation, we must insist on the consideration of ways and means to strengthen it, looking at the practices of the recovery of assets and making use of mutual legal assistance treaties in respect of the most serious crimes. The question of non-cooperation is also a point of concern, especially when it appears in conjunction with Security Council referrals. As you are aware, one of the unique characteristics of the Rome Statute is the incorporation of victims' rights in criminal proceedings and the opportunity for them to participate in these proceedings. Reparations to victims, ordered by the court and implemented by the Trust Fund for Victims, have now become a reality. With this small step, the promise of reparative and restorative justice made in Rome 20 years ago has proven to be far more than just idealistic ambition. It is now a reality for the victims of horrendous crimes. I note also that despite the effective work being done by the Fund, under its assistance mandate, it is crucial to improve the understanding of its work and to raise awareness of the need to provide the Trust Fund with the support and resources it needs to ensure its sustainability and enable it to bring relief to a greater number of victims. The Court, which is a wheel of a chain in a system of integrated jurisdictions, does not and cannot work in isolation. Now I will finish in Spanish. No agregaré más comentarios sobre temas.
I will add no more comments on all these issues which are of great importance for our work as states parties and for the court itself. But there are still a number of issues pending, such as, for example, the interpretation of some of the articles in the statute, which are difficult in terms of how to apply them, or the way in which we approach these issues. In that sense, the states parties should be capable of finding a solution to our own issues and to support support the court along these lines. One last word. Everything that I have mentioned here is just a fraction of the number of issues that have been dealt with here, and of the many more aspects that will doubtless be raised in the following days and weeks. I am more than aware of this. Finally, I wish to thank the coordinator of the working group of The Hague, Ambassador Horslund of Denmark, and all those who have supported me in this work. Many, many thanks to all of you. Many thanks.
Thank you, Ambassador Infante. And with those concluding remarks, we end the commemorative events around the 20th anniversary of the adoption of the Rome Statute held today here at the International Criminal Court. You are kindly invited to join us for some refreshments with a musical performance in the lobby of the court to further the discussions a little bit more in an informal setting. Thank you very much.
Great pleasure. Of course. Great pleasure.